And latency is a delay. It's the time it takes your camera to communicate to the streaming software.
All right. Give us just a moment. And happy Juneteenth. Give me just a moment as we are working everything out. Okay. I'm going to give it about 5 minutes. And then we're going to get started on our live for today. And so just bear with us. We had a little bit of technical difficulties, but we are getting it up and running. We're going to get it up and running this Juneteenth. Mm-mm-mm. All right. Yay, we're back. Hello, everybody. Thank you for your patience. You're having a little bit of technical difficulties, but we are here. Okay. And today, got it. If anybody can let me know if you can hear me. Can you hear me? Can you hear me? All right. So, hello, everybody, and welcome once again. Thank you for the patience. Thank you for your patience. We had a little bit of technical difficulties, but that's just the day that we're in with, technology. It happens. But I am happy to be with you guys today. We're going to be talking about you're going to be talking about IP, intellectual property, and particularly why it's so important right now with, with non-competes now no longer being enforceable. So that is the topic that we're going to be talking about today. So I'm going to start by, talking a little bit about what the new laws has done and what's changed with the new laws, how we can now protect ourselves with this new law going into effect. And then also, if you have any questions, please feel free to put the questions in the chat because this is supposed to be a Q&A. So if you have any questions, put the questions in the chat. I'm going to do the best I can to answer your questions. And let's get started. Yay. So once again, my name is Brianna Robertson. I am the managing attorney with the law office of Brianna C. Robertson. We are based here in Dallas, but we serve, do IP across the United States. But we do have, do services in 4 states: Georgia, Texas, Louisiana, Arizona. So we do, the whole shebang. So that is what we do at my firm. And one of the biggest things that we do with our firm is helping entrepreneurs stay legally protected, which is why today's topic is so important, because in April, the Federal Trade Commission passed the legislation that stated that non-competes are no longer enforceable. There is only a small sector of exemptions on when they will be able to enforce non-competes, but this is only for people who are in like high level positions such as VPs, presidents, board of directors. It's just a very small segment of people that are exempt from the FTC, this FTC legislation. And so that means for just about everybody else, non-competes are not enforceable. And that's okay because in all honesty, prior to that, non-competes weren't, you had to draw them to be very specific in order for them to be enforceable anyway. So non-competes has been on its way out. And with that, we had to get into new ways on how to protect ourselves. So the way that you are going to protect yourselves with non-competes not being enforceable is going to be by protecting your intellectual property. This is going to be, trademarks, copyrights, patents, but the big one here is going to be trade secrets. Trade secrets is a little sector in intellectual property that is going to be key in protecting yourself with non-competes no longer being enforceable. What is a trade secret? Trade secrets are any processes or any processes, ingredients, whatever is unique to your firm that nobody else should know about. That is what is a trade secret. It's literally the secrets of your firm, how your firm works or how your business works, or how your business works. If you have secret recipes, those recipes can be considered trade secrets. And the unique thing about trade secrets is that trade secrets do not have to be registered. Trade secrets, how you protect trade secrets though, is that you have to have certain processes and procedures in place with your business in order to protect your trade secrets. And this is why that is going to be important when non-competes are no longer enforceable. We're going to now use trade secrets. Let me rewind just a little bit because I want to make sure that you guys know what non-competes are and what they actually do. So non-competes, what they do is essentially a clause that we usually put in your contracts, that says that when this person, if you leave this business, you can't start another business that's exactly like mine that's going to compete with my business. And in order for the non-competes to be enforceable, it has to state, the radius that they can't compete in. It can't be, just anywhere in the United States. It has to be like within 30 miles or within 200 miles, depending on the type of business you have. And it has to be for a duration of time. Usually it's like for a year or 2 years. You can't start a business that directly competes with mine. So that's what a non-compete does. And that is really important because if you're hiring employees to come into your business, and are hiring people to work with you, they're going to end up knowing, secrets or unique things about your business in order for them to help you. And you don't want to feel like when you're having these people come help you that they then take that information, then go start the business right across the street from you, or start the same exact business that's now competing with your business, and they took the processes that they learned from you and then used it for themselves to make money. So that is what the non-competes were for, and how traditionally you would protect against that is you would have this non-compete clause in contracts whenever people would work for you, whenever you're hiring employees, whether it be independent contractors, etc. But now the FTC has said that that is no longer going to be enforceable. And the reason that they're doing this is they're trying to encourage more businesses to come out there and start businesses. And so by taking away this non-compete, they're expecting that it's going to be a rise in the amount of businesses that are now going to come forth. With that, though, you as a business owner don't want to be afraid when you're hiring people to come work for you, automatically thinking these people are going to take my ideas and make money off of it. So now that non-competes are no longer enforceable, we now have to think about how we're going to make sure that we protect ourselves, so that way these processes that we take time to create that's going to be unique to my business is not going to be used for somebody else. And so this is where, like I said, intellectual property is going to come into play. And with that, this is the biggest one that you're going to be using when protecting this intellectual property, like I said, is trade secrets. As I had said previously, trade secrets are, the things that make your business unique, the processes and the things that make your business unique. And you do not have to register trade secrets, but you do have to take procedures and have procedures in place in order to protect trade secrets, in order for you to be able to take action and for it to be enforceable. How we do that, how you protect your trade secrets, you do this by having, when you're hiring employees or contractors to come work on your business, you're going to want to have NDA clauses and confidentiality clauses in your contracts. The NDA stands for non-disclosure agreements, and then confidentiality, it's just like it says, keep this information confidential. And then also you're going to want to have sections in your contracts that talk about IP, saying that all of the IP that is part of this business stays with this business, and they're not to go and disclose this information to anybody else, any competing business, or for them their own self. So that is going to be key in protecting yourselves with non-competes not being enforceable. You're going to really want to hone in on these trade secrets. So in your operating agreement, and you're going to want to make sure that you label what processes that your business goes through that is going to be, that you believe is unique to your business. And then you're going to want to label these things as trade secrets. And so when you bring on people into your business that is going to work for your business, you need to make sure it's clear to these employees that this is going to be considered a trade secret, and this cannot be disclosed to anybody, and it cannot be used outside of this business, because that is considered a trade secret. For a trade secret to be a trade secret, naturally you can't go out and telling everybody how it works or how it's used. You have to make sure that it's only used by certain employees. So if one employee doesn't need to have that information, they shouldn't have it. You need to be very clear on which employees are going to have access to this information and which ones are not. And like I said before, make sure that it's clear in these agreements and that they are signing in a contract that they are not going to, that you're not going to use this information. Okay, give me 1 second. So I see we have a question here. So it says, so I have one from Just Joy Hair. You saying that you took a class to become certified optician, saying that you wouldn't teach, and I learned I'm enrolling in cosmetology school for my instructor license. Does this apply? Based off of the new FTC rulings, you signing saying that you would not teach, that now would not apply because that would be considered a non-compete. So them saying that you wouldn't teach, that would no longer be enforceable by by whoever whose contract you signed that with. That would not be enforceable at this time, according to the FTC, unless you were a part of their organization, such as a vice president or on the board where you were like a key decision maker, in which case that you might fall into that exemption. But if you are not in that exemption, that would more likely no longer apply in this scenario. So that's a very good question. But going forward, if you do decide to start your own business, make sure that anybody that you bring onto your business, that you're now having them, instead of them signing non-compete saying that they're not going to teach or going to teach, certain things, that now they're going to say, this process that I have, that I taught you, the specific secret of how I do things, you're not going to disclose that to any outside vendor, and you're not going to, you can't really say you can't use it. You can, but it's going to be really tricky on how you do that language. But really, you're going to want to make sure that that information is not disclosed, so that way that it can't compete with any uniqueness that you have in your business. So very, very good question. Trade secrets, in order to protect those trade secrets, as I was stating previously, you're going to want to make sure you have the NDA clauses in your NDA non-disclosures, your confidentiality, and making sure that it is stated that your IP belongs to your business and cannot be used outside of your business. The same thing goes with if you have client lists that they will not be contacting your client list or using your client list to start their own business, that your client list stays with you. So that is other good information that you're going to want to make sure you're using to protect your business now that you can't use and enforce the non-compete clauses. The other thing is, now that we talked about trade secrets, the other thing is, how do you protect your IP, intellectual property? What is IP? Let's start there. IP is your creative works that you create in your mind. This would be things like logos, your creativity, like artwork, dance, music. All of these creative works are considered your intellectual property. You own the things that you create from your mind. And so how you would go about protecting this IP is, we have four main avenues. We just talked about trade secrets in detail. The other avenues that you would use to protect your IP would be by trademarks, copyrights, and patents. Trademarks is what you would use for branding materials. So anything that you're using towards your branding, you're going to want to get it trademarked. And what we mean by saying getting it trademarked, that means having that branding material or that brand, that logo, those colors, that font, having that registered with the United States Patent and Trademark Office. So you're going to want to have it registered with them, letting them know that this brand, this creative work belongs to me. You'll get a certificate that says that it belongs to you, and that puts everybody on notice that it's being used, and so therefore it can't be used by anybody else that's in the same field as you. So that is one way to protect your IP. Another way to protect your IP is going to be through copyrights. Copyrights are any other creative works, such as artwork is intellectual property. Yes, any type of drawing. So this is where we're getting ready to go into talking about copyrights. Artwork is intellectual property. If you create plays, that is intellectual property. If you are create dance choreography, that is intellectual property. If you do set designs, that is intellectual property. Anything that is creative works is considered intellectual property. In that particular sector, the ones that's not dealing with branding, that would be considered fall under the copyright law. The interesting thing about copyright law is that copyrights automatically attach to the work as soon as it's created by the creator, the person who created that work. However, in order to enforce your rights with the copyrights, you need to register it with the Copyright Office. So just like trademarks, how you have to go and register it with the United States Patent and Trademark Office and get a certificate that says that you own it, the same thing goes for the any copyrights that you do. You're going to have to register it with the Copyright Office, get a certificate saying this piece of work was created by me, and so therefore I'm the original owner of it. And the benefits of that is that if anybody else were to try to take that work, they would be infringing on your copyrights. You can then go and enforce that copyright saying that you're infringing on it, and you need to either take it down or you can license them out and give them permission to use it. They just got to pay you royalties for it. And so you see that a lot with a lot of these platforms where you say, like, I do not own the copyrights to this. And you have to make sure that you're making do that I'm not the one who created it. And then if anybody wants to sample it or use it, they're often having to pay the creator of that work in order to be able to use it. So that is another good avenue in protecting and making sure that people are not taking things that you create, the things that you put your blood, sweat, and tears into creating, and make sure that other people are not going and profiting off of it. Because you can't say they use a non-compete and they can't do that anymore. So now we're going to do the IP protection. And so that way, if anybody were to try to use it, they're now infringing on your intellectual property because you have taken the steps to go and make sure that your IP was protected by one, the trademark route, which is taking your trademarks, going and getting it registered with the United States Patent and Trademark Office, or two, for anything that's not dealing with your brand, you've taken that and registered with the Copyright Office, showing that you own that material and that anybody who wants to use it, they now got to pay you your coins to get some of that. Let's see, it looks like we have another question here. So with AI leading the industry, how do you protect yourselves when using AI to create content when you don't know the source? So with AI being so new, this is actually a new area in the law where there is a lot of debate about, do you own this intellectual property that is being created by AI? Because there's really no law that's really on it. It's very new, and this is where the law needs to catch up with the times and with the technology. You have a lot of people who say that anything that's created by AI, you do not own it because you didn't create it. It was created by this technology that owns it. Sort of like they're likening it to using like Canva templates, for example. So if you creating works off of using templates from Canva, you can't copyright that. And there's actually a clause there that says that you can't copyright it because you didn't create the works, you don't own it, and it's uncopyrightable, and you can't use it for trademarks. The only way that you can use that and register it as your own is if you make significant changes where you're pretty much, changing it from scratch. Then at that point, you can take credit for it. And so the same thing is going to probably go for the AI generated information, where in order to use anything that was created through AI, you have to make significant changes where you are the one that's doing like a lot of edits. So let's say you're doing an ebook made through AI, and then you go through and you make a whole lot of edits through it. At that point, you may be able to say, yeah, I still own the copyrights because although I use AI to create this work, a significant portion of it was from my creative works and not through the AI generated software. And so therefore I still should be able to get the copyrights for it. So that is something that is really up for debate right now, and that we just need to make sure that the law is going to catch up with the times. So this is going to be really interesting to see how this plays out when it comes to the future. So then I have another question. Can you copyright the prompt that you use to produce work in AI? If you're something that you created, sure, why not? Creative rights would be if it's something that you created that is something unique that's not already out there. Like if I put in, how do you make this food? That's something that clearly can't be copyrightable because that's generic. But if you put something that is a unique to you, your creative works, and you're asking AI to create something from that, I would argue that yes, it should be able to be copyrightable. So very good question. Very good question. And like I said, I'm just really excited to see how this is going to play out with the AI, because a lot of lawyers are going back and forth of, can we copyright this? Who owns this work? It's really just a new area of law that we are trying to see, how the law catch up with the times. And so I'm sure we're going to be seeing some court cases come to the court soon, arguing this very issue, where we can actually set groundwork like, oh, this is definitely not going to be able to work, and this definitely is going to be able to work. So good question. Keep them coming, guys, because I definitely want to answer your questions while you're on this live. So I did talk about trademarks, and then I talked about copyrights and how you get them. Do know that with trademarks, when you apply for those, that it does take a long time to actually get that registration certificate, because the USPTO, which is the United States Patent and Trademark Office, is greatly backed up right now. And so with that, it's taking them about a year to a year and a half to get trademarks registered right now. But the good news is that your trademark protection and your trademark rights revert back to the day that you applied. So you do not want to sit on waiting to apply for your trademark, because the first person to apply for it is the one that gets it. And there's like few exceptions where you can try to boot them out and say like, no, I'm the rightful owner of this. But those are a few exceptions, and very costly to fight that out in the courts to say that that person shouldn't get the trademark, I should get the trademark. It's just best to just go ahead and register your stuff now as soon as you get it, and not have to spend the multiple thousands upon thousands of dollars to fight it out to try to get it in the back end. And the time to fight for your trademark and branding rights is not when you make it big, because at that point you don't want to risk losing your branding and having to change everything when you've made it big. Take care of all of that stuff in the beginning. Definitely take care of all of your IP, especially your trademarks and branding and things in the beginning before you scale. The same thing goes for copyrights. Yes, you do get the copyrights, as soon as you make it. But if somebody else were to copy your work and then you go to the court saying that you infringed upon my copyrights, you're now in the fight of trying to prove who actually made the work first. Versus if you just go and register it right away, there is like proof, like I created it on this date, and as soon as I created it, I went and registered it. So this is what in the legal terms, legal jargon, is saying prima facie proof, or is proof that I am the one who created first. And so it cast the burden on the other side to prove it. You've already met your burden because I already registered my stuff. So now it's on them to prove that I didn't create it first. And that's why it's so important to register your copyrights as soon as possible. And then if you register it within the first 90 days of publishing it, then you're able to also get damages such as attorney's fees and damages from copyright infringement. So that is another way to protect your yourself and your business and your IP. The third avenue that we use to protect IP is going to be patents. Patents is what we use for inventions, technology, all of that stuff is what falls under patent law. And patents take a long time to get, but they are worth it, and they last about 20 years. So to go over, just once again, as a recap, the ways that you're going to protect your business now that non-competes are unenforceable, except for in, very small amount of sectors and exceptions. You're going to be using our IP protections. That is going to be things such as trade secrets. You're going to be using your trademarks. You're going to be using your copyrights. You're going to be using your patents. These are going to be the avenues that we're going to use to protect the things that belong to your business, to prevent other people from being able to copy it and use it and profit off of their business. So IP is going to be, top notch, the vehicle that you're going to want to use now, and making sure that you include that in your contracts whenever you are hiring other people or contracting with other people to work with your business. You're going to want to make sure it's clear that the IP that is owned by you and that nobody else can use it unless you license it out and they pay you to use it. And then also making sure that you have these NDAs, these non-disclosure agreements and confidentialities in your contracts to protect the things that belong to your business. So that is pretty much that in a nutshell. Is there any other questions? This Joy said, how strong is a poor man's patent? I don't like them. It's not that strong at all. So those things are just asking for a lot of litigation to happen. Asking for a lot of litigation to happen. Fight that out in courts. You need to go through the legal grounds and figure out how to do it and just register it through the Patent and Trademark Office. One moment, you guys. Any other questions, please keep them coming. Any other questions? And give me 1 second. So a poor man's patent. So I have a question here. What is a poor man's patent? A poor man's patent is something that a lot of people in the older days is this trick saying, you write out your idea, you write out your invention on a piece of paper, you send it out in the mail, and you mail it to yourself. And by doing that, you now have the patent protections instead of having to go through and register it with the government and registering it with the, USPTO. That all you have to do is write it out and then mail it to yourself, and that makes it enforceable as a legitimate patent. And that is not. No, you cannot use that. That is not. That does not work. I'm sorry, you guys. Yeah. So, yeah. Poor man. I'm sorry, you guys. I just had a quick interruption. But yes, a poor man's patent, like I said, what it does is it was something that they did back in olden times when it wasn't really based upon first to file and all of that stuff. You literally just wrote it out, mailed it to yourself. And the theory behind that is, oh, my bad. Okay. Sorry, guys. I started to see my phone. Good now. Okay, guys. So yes, a poor man's patent pretty much is like I said. You mail it out to yourself, put it in the mail, you got it, and then theory was by doing that, you now own the patents behind it, but that doesn't work. It's not legally sound. Any other questions? Okay, so if there are no other questions, I'm looking here and I'm trying to use my phone because for some reason I can't see it on my computer. Okay. If there are no other questions, I just want to let you guys know that I am here for all of your business needs. One of the main pillars of my firm is helping legally protect businesses. This is a passion that God gave me a while ago when he told me to start my law firm. He said, I'm raising up businesses, I'm raising up new entrepreneurs, and he has put me in a position to help be an advocate on behalf of the entrepreneurs that he is raising up. Because he has shown me that, a line is being drawn in the sand of, businesses that, are legit and that are, as you see right now, everybody's getting exposed. And so a line is being drawn right now. Businesses that are legit and working with integrity and those that are not. And if you're not willing to go with the government system or how they like to do things, please believe they're getting ready to start coming after people. But that is okay, because we do not need to be worried, because God has already prepared for that. He has raised up advocates such as myself. He's raised up advocates such as myself to be able to stand in the gap when these people try to come for you with opening these businesses and you don't do it their way. He's already raised up advocates that are here and prepared to fight for you. And that is what we do in our firm. We are here prepared to fight for you and to make sure that, one, you're legally protected. So that way, when they do come for you, you already have the protections in place for you to be able to, you have the protections in place to be able to go and do what you need to do. And that way, I tell people, all my clients right now, you go and you do the business that God has called you to do. You help us. We do handle the legal stuff. We stand in the gap for you and handle the legal and the court stuff. So that way you can go do the purpose that God has called you to do. And so that is what we do here at my firm. We're here to legally help you legally protect your business. We do this by saying, helping you guys with contracts. We help you by protecting your IP, by doing copyrights, trademarks, including estate planning, because businesses need to do estate planning and succession planning too. We do that for you guys as well. We help with business litigation. These are all the things that my firm does to help you with your business. So please feel free to contact us. After this live, you will be getting an email with different offers for you being on this live, for you joining us today. We're giving you guys a special offer where you're getting 15% off of our trademark services and 30% off of strategy calls. Strategy calls is an excellent avenue to use if you don't exactly know what I need in my business, what all legal protections I need to worry about, how should I form my business. This is the best time to hop on a strategy call where you have an hour with us and we help walk you through what you need and come up with a strategy on when you should get them. So, so please hop on. 15% off trademarks, 30% off strategy calls. And this is just for you all. So we know who registered. We know who's on the live. So don't share the link that you get, because we're going to be able to verify, who was able to get these discounts. But we want to help you. We want to make sure that you're legally protected, so that way you can go out and do what God called y'all to do and live out your purpose without fear that somebody's going to come and try to take it away from you, i.e. the government or somebody trying to come and sue you. So that is what we're here for. We're here to help y'all. BC Robertson Law. We're here and excited to help you guys. And if you don't have any more questions before I head out, and I hope you guys have enjoyed your Juneteenth, and you can enjoy the rest of your evening and enjoy the rest of your week. I do have a family, so right after this, I'm going to go right into mom mode. So, thank you guys for joining. No other questions. See you guys next week. Same time, 7 p.m. And we're going to be talking about a new topic here every Wednesday. So join us. Bye, guys.